Well, Stephen, Happy New Year to you, sir. It's good talking to you again.
Happy New Year and happy holidays to you, Cam.
It's good to have you back. Tonight we're going to be talking about one of the many cases that the NRA is pursuing in California, right?
That's correct. It's the case of Peruta versus County of San Diego. Now, the plaintiffs in Peruta County of San Diego, in Peruta versus County of San Diego, they filed a suit because they were all denied concealed carry permits, either the initial application or a renewal application by the San Diego County Sheriff's Office, or else they were just advised not to apply at the very beginning by the county clerks because they lacked good cause for the issuance of a permit. And by the way, when these county clerks advise you not to apply, that's just another way to get people not to exercise their rights without actually having to deny them. They just make these people go away. Now, here's the deal. Under California Penal Code, Section 12050, as long as you're not disqualified from possessing a firearm, like a felon and mentally adjudicated, mentally defective or something, then if you're not one of those, if you're a law-abiding citizen who's not disqualified, the requirements for applying and obtaining concealed carry permit include a number of requirements, including a showing of good moral character, residence, a showing of good cause, completion of a firearms training course, and one of the problems that a statute like this creates, Cam, is that local county licensing authorities have the discretion to determine, what is good cause. Okay, and the question is self-defense good cause for issuing a CCW permit? Now, some local jurisdictions accept the claim of self-defense as being good cause for issuance of permits, while other local licensing authorities do not recognize the right of self-defense as, quote, good cause, unquote, for the issuance of a permit, because that's, again, required in the statute that you show good cause.
Right.
And at issue in today's case is this good cause requirement, which the County of San Diego, the Sheriff's Office Department in the County of San Diego defines as follows, quote, a set of circumstances that distinguishes the applicant from other members of the general public and causes him or her to be placed in harm's way, and generalized fear for one's personal safety is not, standing alone, considered good cause. To demonstrate good cause, new applicants must provide supporting documentation, unquote. In other words, you saying, hey, I want to protect myself and my family, that's not good enough. You've got to show some a specific circumstance, and you've got to file documents, supporting documents that support your claim that you have something really to fear, a particularized fear, a particularized threat. Okay, and when the applicants were denied their concealed carry permits, they filed a lawsuit against the county and the sheriff in federal court, claiming making constitutional claims and also civil rights claims. And in the lawsuit, the plaintiffs argued that the right to keep and bear arms recognized in Heller and incorporated against state action in McDonald includes the right to carry a loaded handgun, either openly or concealed. And the fact that the County of San Diego asserts that self-defense is not considered good cause under Penal Code Section 12050 is unconstitutional. Because remember, Cab, that's what the Supreme Court said in McDonald and Heller. Is this is the core right is the right of self-defense here, and also there's really no other practical outlet for lawfully carrying a firearm for self-defense under California law. Now, unfortunately, last month on December 10th, the United States District Court for the Southern District of California disagreed. Okay, this court held instead that California Penal Code Section 12031 provides a sufficient outlet for self-defense. Now, Cam, actually, Penal Code Section 12031J1 permits loaded open carry by, quote, a person who reasonably believes that the person or property of himself or herself or of another is in immediate grave danger and that the carrying of the weapon is necessary for the preservation of that person or property, unquote. And you must also have notified the police within, quote, a brief interval, unquote, of carrying the loaded firearm. And then Penal Code subsection 12031J2 also permits loaded open carry and remember, both of these are open,
Right.
if a person, quote, reasonably believes that he or she is in grave danger because of circumstances forming the basis of a current restraining order issued by a court against another person or persons who have been found to pose a threat to his or her life or safety, unquote. But, Cam, this is no good. I mean, first of all, this is only open carry, but second of all, the exceptions to the prohibition on open carrying, they allow open loaded carrying only if there's a current restraining order issued by a court which states that another person poses a threat to your life. So, in other words, yeah, you can carry openly, but only if there's a restraining order out that you've already gotten, and the order says there's somebody who's a threat to your life. Now, that may be applicable in some cases, but, that's not going to be applicable for the majority of the public, you know. And then the other exception is the first one I'd actually mentioned, and that, even though it doesn't require a court restraining order, it does require that you prove you are, quote, in immediate grave danger, unquote, and that it is necessary for you to openly carry a loaded firearm for the preservation of your life, and you must have notified the police within a brief interval of carrying. And again, that's a high hurdle. And the worst of all is, even if you fall into one of these two exceptions to the prohibition on open loaded carrying, all this does, it doesn't give you a permit to carry. It gives you a defense that you can raise when you're being prosecuted for violating the law for carrying openly a loaded gun. And again, you have to prove that you fall within one of these exceptions.
Yeah.
Okay? Now, the court said that there's nothing in California law that prevents the right of self-defense in the home, and nothing to prevent the open carrying of an unloaded firearm and unloaded ammunition, if the need for self-defense should arise. Of course, the plaintiffs pointed out, well, this is not adequate. You have a right to carry an unloaded firearm. Even if you have ammo on you, the need for self-defense can arise in a split second. You don't say, excuse me, Mr. Rapist, while I load your gun to shoot you with. That's not how it works,
Yeah.
At that moment, an unloaded firearm is of no help at all, Now, like I said, the court ruled against the plaintiffs in this NRA case, and notice of appeal, however, has been filed, and there's a telephonic settlement assessment conference scheduled for later this month on January 31st, and hopefully on appeal the case will be decided differently. Now, on the positive side, Cam, you got to note that the judge in a January of 2010 motion to dismiss hearing, that judge denied the county's motion to dismiss, and again, in this past month's decision, the December 10th decision, she again reaffirmed, as she did in the motion to dismiss back in, a year ago, that the U.S. Supreme Court decision in Heller and McDonald, provide for an individual right, and that the plaintiffs, in this case, have a Second Amendment right to openly carry an unloaded firearm in public for the purpose of self-defense. And that may not sound like much, but the Brady campaign to prevent gun violence, the gun prohibitionists, they had filed an amicus curiae brief in this case arguing that the right to carry a loaded, fully functional firearm, the right to have a firearm at all, never extends beyond the home. Okay? So the judge holding that, look, your right to carry an unloaded handgun and unloaded ammo that you can then load if the need arises, I mean, that's kind of rejecting. I mean, that is specifically rejecting the argument that the gun prohibitionists were making, namely that you have no rights whatsoever in regards to the Second Amendment once you step outside of the door. And, Cam, this is important, and let me tell you why it's important. In the past legislative session in California, a ban on openly carrying handguns was introduced and was narrowly defeated on parliamentary grounds. And the gun prohibitionists, when they were pushing this bill, and the sponsors, they argued that the U.S. Supreme Court's Heller and McDonald decisions did not create a right that extended in any way beyond one's home. Again, their argument was, look, okay, we got to swallow the Second Amendment right because the Supreme Court forced us to, but it only extends to your home and nowhere beyond. But the Peruta case, even though it didn't come out the way we wanted to at this stage, and remember, it's just being appealed to the U.S. Court of Appeals, the Peruta case makes it clear that there is an individual constitutional right to carry a firearm outside of the home for purpose of self-defense. And this will make any future attempt by the gun prohibitionists to introduce a bill like the one that was introduced in the last legislative session much harder. And then lastly, Cam, I do have a good feeling about the future in this case and in other case, and let me tell you why. I have a good feeling about the future of this appeal or a separate future challenge to some of these California statutes. And the reason I do is because, if you remember in the Heller decision, the justices derided the absurdity of the D.C. law which required a person to keep his firearm unloaded and locked and disassembled.
Yep.
Well, if you take a look at the California law, in the Peruta decision, they said, well, look, you've got a Second Amendment outlet to carrying because you're allowed to carry your gun unloaded. Okay, well, that doesn't really jive with the language in the Heller decision where the court said, an unloaded gun or a locked gun is of no use. You got to be able, at least in your home, to have a loaded gun ready for use. Because I don't know if you remember the back and forth with I think it was Justice Scalia, who was giving the D.C. government a hard time when they were suggesting that a disassembled gun has any value at all in self-defense in the home when the burglar breaks in.
Yep, I do remember that.
Yeah, so I think let's see what happens on the appeal, and I think in other challenges. Hopefully this will work itself all out in our favor. But in the meantime, like I said, while the case didn't come out exactly as we would wish, it did reaffirm back in the January 2010 motion to dismiss hearing, and in this December 10th opinion, that there is an individual right to keep and bear arms based on the Second Amendment for carrying a firearm outside of the home, not just in the home.
All right, Stefan, as always, sir, a pleasure getting a chance to talk with you, and I look forward to doing it again very soon.
Looking forward to it.
Stephen Thomas, CB, Deputy General Counsel of the National Rifle Association, joining us here tonight on Cam and Company.